Hello and welcome to a special interview for The Wire. How significant was yesterday's Supreme Court ruling on sedition? Or does it raise issues and concerns that are perhaps cause for doubt? That's the key issue I shall explore today with one of India's foremost and most senior Supreme Court lawyers, a former president of the Supreme Court Bar Association, Dushyant Dave. Mr. Dave, let's start with the Supreme Court's announcement yesterday about the sedition law, which the press has interpreted as a pressing of the pause button. Some newspapers have said that sedition has been put on hold. Others have said it's in abeyance. How do you, as a senior lawyer, view this decision?
See, first and foremost, I think the country is entitled to know one thing, and they must know that this was an historic order. And every Indian must be eternally grateful to the Supreme Court for this order, because it's really an extraordinary event that has taken place in the history of the court. I mean, passing of a stay order, staying, virtually implementation of a, provision in a statute which has been on the statute book for century is something unheard of. And yet, Supreme Court has gone ahead and done it. So I think it's very, very important for everybody to understand how important, how, far-reaching this is. Having said so, I must say that there is a complete stay on implementation of section or enforcement of section 124 capital A, which is the provision relating to sedition. So no new cases can be filed, and the pending cases have been stayed by the Supreme Court. So I think to that extent, the court stay order is a very, very wide and very far-reaching.
Well, let me challenge what you said. You've called it historic. You said the country should be eternally grateful. More importantly, you said, and these are your precise words, there is a complete stay order on filing new cases under Section 124A, which is the sedition clause. I'm going to now quote the Supreme Court's language. It does not suggest a complete stay order at all. This is what the Supreme Court says. We hope and expect, I'll underline those words, we hope and expect that the state and central governments will refrain from registering any FIR, continuing any investigation, or taking any coercive measures by invoking Section 124A of the IPC while the aforesaid provision of law is under consideration. So I put it to you, this is not a complete stay order. This is just hope and expectation. And how can the Supreme Court be confident that its hope and expectation will be adhered to and obeyed? Because it's not an order. It is only hope and expectation.
Well, you are reading paragraph 8b, but you are missing paragraph 8c, which says if any fresh case is registered under section 124 capital A of the IPC, the affected parties are at liberty to approach the concerned courts for appropriate relief. The courts are requested to examine relief sought, taking into account present order passed as well as clear stand taken by Union of India.
But you proved my point. You're proving my point by what you read out. Remember how you began. If there is any fresh case, just remember those words. If there is any fresh case registered under Section 124A, that clearly means that the Supreme Court is not confident there won't be fresh cases. They're envisaging fresh cases, which means it's not a stay order. They're already concerned that their hope and expectation may not be adhered to. That again indicates clearly that this is not a complete stay, it is a hope and expectation, and they're worried there may be fresh cases. Therefore, they're also saying what should happen if there are fresh cases. You're proving my point.
There are many ways the courts exercise these powers. If the court had directly granted a stay, the government would have, really cried foul and said that you have no power to do so. Now, please see, for example, 8D. The court says all pending trials, appeals, and proceedings with respect to charge framed under Section 124 capital A of IPC be kept in abeyance. Now, that's an express stay. So there is no doubt that the court has couched its order in such a beautiful way that the government really has no reason or basis to say that Supreme Court has overstepped its jurisdiction.
Mr. Dave, let me point this out. About a year ago, when the Supreme Court was handling the 3 agricultural acts, it put a complete stay. And it wasn't worried about the government shouting foul. This time round, they haven't put a complete stay. They've only expressed hope and expectation. And this fear that you have that the government would have cried foul is an unrealistic fear. They didn't cry foul in the agricultural cases. Why would they cry foul now?
No, I won't agree to that, because in paragraph 7, the court says, therefore, we expect that till re-examination of provision is complete, it will be appropriate not to continue usage of the appropriate provision of law by the governments. Now, once court speaks in this language, it is virtually a stay. No
Well,
court.
hang on a second. Hang on a second. You very interestingly changed your terminology. When you answered the first question, you said it was a complete stay order. Now you're saying it's virtually a stay, which is not a complete stay order. But let me, in support of my argument, quote a gentleman who you probably know better than me, Chitranshul Sinha, writing an op-ed in today's Indian Express. These are his precise words. The order should have been more assertive and explicit in this regard, and should have provided penal consequences for its non-compliance. So I'm not the only person who says that this hope and expectation falls rather poorly short of a complete stay. Chitranshul Sinha is saying the same thing.
No, I don't agree to Mr. Sinha's assessment, because, I mean, once the Supreme Court couches its order in whatever language you call it, this order will be understood by everybody, every policeman in the country and every court, as a stay. And I don't think any government will have courage to now register a case under Section 124.
No, hang on a second. You know better than me that the Supreme Court in 2015 struck down, not stayed, struck down Section 66A of the IT Act, and it continues to be enforced. And that was struck down. Here, it's not even stayed. It's a hope and expectation.
You are right. It was not properly advertised. This particular order is now advertised across the country. Everybody knows. Everyone has taken notice of it. So I have no doubt in my mind that there is a stay order granted without actually using the word stay by the Supreme Court. So
well, that's a matter of clever interpretation, but I like your phraseology and I applaud it. It's a stay order granted without using the word stay. Actually, the word used is hope and expectation. And secondly, the Supreme Court has actually envisaged that there could be fresh cases. And it's also then said how those fresh cases should be treated. Bail should be granted expeditiously, but you know and I know that those applications for bail will not go to the Supreme Court. They'll go to magistrates' courts and high courts, and they will not be treated expeditiously. So even there, where the Supreme Court hopes that the remedy, bail, will be expeditious, at the lower judiciary level, it won't be.
No, I don't agree, because the moment court has stayed all the pending proceedings in clear terms, then even if an FIR is registered and accused brought to the court under 124A, the magistrate is bound to stay the proceedings straight away, because he will say that all previous proceedings are stayed. Therefore, I will stay this proceeding also. So I think there are enough safeguards in the order.
Well, I hope for your sake, you're right. I hope my fears and my doubts and my concerns are wrong, because otherwise, an awful injustice will have been done to people who, regardless of the fact that the Supreme Court has expressed hope and expectation, will still find they are being charged with sedition. I can't understand why, but this is my last question on this, and then I'll come to another matter. I can't understand why a Supreme Court, if it's being brave, if it's being bold, if it's being historic, that's your phrase, couldn't have said, we stay full stop. Why put it as hope and expectation? Why not say we stay full stop?
Because the Supreme Court was giving government a chance to do what government has promised to do in the Supreme Court on a solemn affidavit. The government has acknowledged the misuse of the provision. The government has acknowledged civil liberties are being impaired.
But 48 hours earlier,
re-examine.
See, Mr. Dave, 48 hours earlier, the government's position was the exact opposite. So where does the Supreme Court get this hope or this conviction that what it's saying in the second affidavit is what it will stand by, not the first?
No, government filed an affidavit on 9th of May. Now, that affidavit is what Supreme Court order has really taken on cognizance of. So, I don't think earlier affidavit has any. See, how do you look at it? The cup is half full or half empty? So
It
to
looks
my mind,
dreadfully, it looks very half empty to me,
to
not
my
half
mind,
full.
to my mind, it is full, not even half full. So
Let me
I think I don't think the court could have and should have done anything more than this. If they had
let
done
me
anything more than this, the court perhaps could have been. See, you talk about the stay of the farm laws. Perhaps the government then wanted the farm laws to be stayed. So because it was.
You're coming very close to suggesting some sort of secret collusion between the
No, no,
government
no.
and the
I'm
court.
not
I'll
suggesting that.
sidestep
The
that
court,
completely.
not at
Let
all.
me
Not at
let
all.
me
The
let me
government
tell
was
you.
happy
Let me
about it. Government never moved the court for vacating the stay order.
But hang on, let's not get on to the farm laws. That's a divergence. It's a different issue. I only brought it up as an illustration. Let's come back to why I think the cup is only half full, not full. And it's a third problem with the Supreme Court's language. I'm going to quote the Supreme Court once again. The court says, all pending trials, appeals, and proceedings. Mark those words. All pending trials, appeals, and proceedings with respect to the charge framed under Section 124A of the IPC be kept in abeyance. This time, it's an order. It's not hope and expectation, but this is the critical bit. All people charged with sedition who are appealing will find their appeals are kept in abeyance. Why? This is an injustice to them.
No, it's not. Supposing the appeals were to proceed and he stands convicted under 124A, the court feels that that would be unjust. It would be illegal. So until we decide the case, we don't want people to be convicted under that.
But please, just remember the conviction rate under 124A is 3%.
That's not the issue.
The chance of people being convicted is minimal. The chance of people being acquitted is huge. But when you stay appeals, those huge number of people who could be acquitted now will be left in the lurch. This is an injustice to them.
Criminal jurisprudence has one very beautiful principle. 100 men who can be declared to be innocent, but one guilty man should be convicted, or otherwise 100 one innocent man should never be convicted. Now therefore one innocent man stands convicted under 124A. If the appeal is heard, or proceeding is heard, or trial is heard, then it makes no sense. So I think it's something.
I get the feeling, I'm not being facetious, but I get the feeling you're bending over backwards to find some sort of justificatory logic in what the Supreme Court has done.
I think that you are not reading the order correctly. You have made up your mind to say that this order is not a great order because there is no express stay. I don't think that's the way the order should be read. So I totally disagree with your understanding of the order.
Which is absolutely your prerogative, but let me put it like this. The website called An Area of Darkness, forgive me, a website called A Decade of Darkness, says that there are 13,000 people in jail facing charges of sedition since 2010. And Kapil Sibal quoted that figure himself in the Supreme Court yesterday. When the court orders that their appeals be kept in abeyance, the Supreme Court is putting them at a terrible disadvantage. And worse still, we don't know how long that abeyance will last. It could last till the third week of July when the matter is heard again. It could last for another year or two. We have no idea how long it will last. So these people are not being put at advantage. They've been put at a disadvantage. They've been left in the lurch. Instead of giving them a lifeline, you've crushed their hope.
No, I don't agree to that. But for this order, they would have to face 124A. I don't know how many would be convicted and how many would be declared innocent. Yes, you may be right. The percentage is very low. But even that 3% of people, why should they face 124A, conviction? So that's how the court has looked at it. Court is examining it.
But in the balance, the 97% of people who could be acquitted now can't get acquitted because their appeals are on hold. That's the other side. 97 will suffer, so that 3 don't.
Karan, how many years their appeals are pending? Find that out first.
All the more reason not to delay it further.
No, it's just to ensure that ultimately, in a right way, the matters can proceed. Okay. There is no need to, it will be an exercise in futility if tomorrow the Supreme Court says it's unconstitutional.
Let me quote to you, in contrast to your opinion that this is historic, that this is something we should be eternally grateful to, the conclusion that Chitranshul Sinha comes to in his article in the Express today. I'm quoting him word for word. This order appears to be a small win, but it's left a lot to be desired.
Well, that's his viewpoint. Even a small win from the Supreme Court, to my mind, is a historic win, because ultimately the court has done something which is, which is so important, so far reaching, that, for a court to say that a provision which has been on statute book for over 100 years, that provision should not be enforced, is something which is very good. I mean, it's in the step in the right direction. And therefore, when the court ultimately hears the matter, the court will take the view one way or the other. The court has given government a rope to really
Okay,
come
I'll
forward.
I'll accept what you're saying, except that I'll briefly point out the court has not enforced that 124 should not be implemented. It's expressed a hope and expectation. But you want to interpret that as enforcement, that's your prerogative. Let me come to what the law minister said. And if I've got my chronology right, Kiran Rijiju spoke literally minutes, maybe at the most an hour after the court delivered its ruling. And these were his words. The court should respect the government and legislature. We have clear demarcation of boundary, and that Lakshman Rekha should not be crossed by anybody. Now, I accept that Mr. Rijiju's words are not explicit in their clarity, but nonetheless, they clearly indicate that he is not a happy man with what the court has done.
Correct. And that, I think, proves my point. If the law minister of the country is unhappy with the order, that means that it's a stay order. And the minister is therefore expressing his grievance that the court has overstepped its limit. So, these two orders. So, I think. I think his statement must be viewed by me as really taking a contrarian view to what you have been suggesting for last 30 minutes. Having said so, I must say one thing, that the minister is not right in saying Supreme Court has crossed Lakshman Rekha. Supreme Court is the ultimate custodian of the fundamental rights of the citizens. It's the ultimate custodian of the civil liberties and the basic human values.
Okay.
So Supreme Court is paramount. It has greater duty and responsibility than even Parliament has. Therefore, Supreme Court intervening in this matter, I think it's a welcome step. It's not crossing Lakshman Rekha at all. It has exercised power which is bestowed upon it by the constitutional framers.
I hope you're right in saying that the law minister is not a happy man because he is forced to accept what you call an enforcement by the Supreme Court. I dispute whether it's an enforcement. There may be another reason why he's upset. There could be a different reason why he's upset, that he realizes that a challenge has been thrown at the government, which the government will defy, and the government will probably carry on implementing 124A, ignoring the hope and expectation, and that will be where the Lakshman Rekha gets crossed. This phraseology from the law minister can be interpreted both ways. It's not necessarily proof the Supreme Court's right. It could be proof that the government will defy the Supreme Court, which is why, as law minister, he's not a happy man. He feels he's been put into an invidious corner by the judges.
Well, look, the Supreme Court has given an opportunity to the government, which has admitted that this provision is pernicious and it is being misused. So Supreme Court has given the government an opportunity to really undo it. Now, if the government is unable to undo it for its administrative reasons, many times it happens. There's nothing wrong about government taking a particular view against the hope expressed by the Supreme Court. Okay. In that case, the Supreme Court will go into constitutionality and pass appropriate order. Nothing wrong about that at all.
Let's move on at this point. We've discussed Section 124A very comprehensively. We've discussed precisely what the Supreme Court has done and how effectively it's done it, and what are the concerns and issues that still leave room for doubt. But let me now come to something the Supreme Court hasn't spoken about. And again, at the cost of annoying you, I'm going to quote Chitranshul Sinha. He says in his article, the language of Section 124A, are you there, Mr. Dave? We seem to have lost you. Mr. Dave? Mr. Dave, have you by accident pressed some button to disconnect yourself? You do remember we're live at this point of time? Oh dear, I have a horrible feeling we have lost Dushyant Dave. For the sake of the audience, I'll point out that the entire discussion that I intended to have with him about the significance of what the Supreme Court has done in terms of the sedition law, or whether it's raised issues and concerns that are cause of doubt, that entire discussion was complete. I was now going on to talk to him about two issues the Supreme Court hasn't as yet said anything about: UAPA, that's the Unlawful Activities Prevention Act, as well as the National Security Act and the Kashmir Government's Public Safety Act. Unfortunately, since we don't have Mr. Dave, that part of the interview we cannot do. I also wanted to ask him about comments he had made last year when Chief Justice Ramanna first became Chief Justice, how he had great hopes and expectations, and he believed, as he said, that the new Chief Justice must make great efforts to overcome the distrust that has been built up about the behavior of his fellow judges. And I wanted to ask him whether now, with this sedition ruling, he believes this Chief Justice has lived up to his expectations. Those were the issues I would have raised. Sadly, I don't have a chance to do it, and we're going to have to leave it there. But please accept one thing: the entire discussion about the Sedition Act was full and complete. My apologies for this break. Goodbye.